Senate will come to order. In lieu of a devotional, we will have a moment of silence. Thank you. Are there any announcements? Seeing none, we have a House bill for referral, H710, an act relating to defining electricity generating facilities. Please listen to the first reading of the bill.
H710, an act relating to defining electricity generating facilities.
Now the bill has been read for the first time and is referred to the Committee on Finance. That brings us to the orders of the day. We have up for action S210, an act relating to access to autopsy reports, which was referred to the Committee on Health and Welfare, which reports it has considered the bill and recommends that the bill be amended as appears in today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of the bill.
S210, an act relating to access to autopsy reports.
I'd like to recognize the senator from Washington District, Senator Cummings.
Thank you, Mr. President. This 210 was submitted by the senator from Addison, senior senator from Addison, as a response to a constituent's request or concern. And the issue we were trying to deal with, and we had two witnesses. We had an anonymous member of the public, and we had Chief Superior Judge Zone. The situation that we were being asked to rectify was that the witness, her daughter died unexpectedly, I believe in her sleep, and the daughter had two young children. The father of the children had been out of the picture for a long time, lived out of state. He arrived back in, had himself declared guardian of the children, and then took the kids and moved out of state. The children, as the heirs, had the right to the autopsy report. And the father, who was estranged, at least from our witness and apparently from the mother of the children, the end result was that this mother could not find out what her daughter died from, what had happened to her daughter. And that was really, along with the grief, the not knowing was a heavy thing for her. And we listened to the story and we were gung-ho. We were going to fix it. And then Judge Zone came in to testify. And he said, yeah, but have you considered? And we kind of looked at him and said, well, no, I guess we haven't. And so the language you have before you reflects the feedback from Judge Zone, plus this wording has been submitted to the state's attorneys for their input. And what it does is it just puts some guardrails around who can have access and under what conditions and what the process is for getting access to an autopsy report. We didn't want a member of the press going in and saying, well, I'm interested and I'm the press and you have to give this to me and it'll be on the front page next week. So it says an individual who is not authorized to receive the autopsy report may petition to the probate division of the Superior Court for a copy, and it will contain an affidavit attesting to the petitioner's relationship to the decedent and the reason the petitioner is seeking the autopsy report. The petitioner will also notify the Office of the Medical Examiner's Office and the state's attorney in which the death occurred. And the state's attorney will have 14 days to respond after the notice. If the Superior Court finds that the petitioner has demonstrated good cause for the petitioner to obtain a report and the state's attorney doesn't object, it shall be ordered and that person will be able to receive it, but they in whole and or part, and the chief medical examiner will do it, and they may place restrictions on the petitioner's dissemination of the copy of the report. And so there will be some discretion as to why that person wants to receive it, but maybe there's a reason not to receive all of it. These are frequently family issues, and they can get very complex and emotional very quickly. And nobody wants anybody going out and disseminating information just to whoever they feel like. And then it sets out what is determining good cause. It's the relationship of the petitioner to the decedent, whether the disclosure is necessary for the public evaluation of governmental performance. I believe that would be if somebody thought maybe there were bullet wounds and the police didn't follow through. Maybe somebody should know that kind of thing. Whether disclosure is necessary, it's governmental performance, seriousness of the intrusion into the decedent's privacy, whether the disclosure is the least intrusive means available, and the ability of similar information elsewhere. So it's only, you have to have a good reason, you have to be related generally to the petitioner, to the deceased, you are the petitioner, and you can't just disseminate it anywhere, but there is this kind of narrow area in which the courts can allow you to see some or all of the autopsy report. I believe the vote in committee was 500, and we asked the Senate to concur.
Thank you, Senator. Question is, shall the bill be amended as recommended by the Committee on Health and Welfare? The Senator from Addison.
Thank you, Mr. President. I would like to just thank the reporter of the bill and the entire Health and Welfare Committee for taking this bill up and doing so with so much care. This bill did, as the senior senator from Washington noted, come out of a family tragedy in our district. It is one way of providing some kind of closure. And I just really appreciate it, and I really ask the Senate to approve this. It is probably a provision that will not be used very much, but when it is used, I think it could have a meaningful impact on families who find themselves in this type of situation again. So I thank you for your support. Thank you, Mr. President.
Senator from Windsor.
Thank you, Mr. President. I'm supportive of this language, and I think it makes sense. I have one question that I believe the reporter of the bill may be able to help address, so I'd like to inquire of the reporter of the bill.
The reporter will be interrogated.
Thank you, Mr. President, and thank you for providing your report on this bill. My question relates to a situation in which the autopsy might reveal a cause of death that then I would seek a civil lawsuit in relation to, perhaps information that I learned that there was factors that a company may have caused harm that led to the ultimate death of the person. How would I, as an individual, let's say I was the person receiving the autopsy report, would I be able to use that as evidence in a court case? Would I be able to use that to bring a court case?
I think you would have to you would have to reveal why you were seeking this to the probate court in order to get the autopsy report. So whether or not you had enough interest to get that would be a determination of the court, and then it would also be a determination of the court or the state's attorney or the medical examiner, whether or not there would be a limit put on your ability to disseminate that information. So if you told them you were doing an investigation into deaths from a chemical in the well water, and that this was, necessary for you to know that, and they decided that was okay, then they probably wouldn't tell you. They may tell you you needed to keep the names separate, but that would all be part of what was revealed and either allowed or not allowed through the courts.
I appreciate that answer. Did this bill go through the Senate Judiciary Committee as well?
It is my understanding that a copy was given to the Judiciary Committee, but we have not heard from them.
Okay, thank you, Mr. President.
Question again, shall the bill be amended as recommended by the Committee on Health and Welfare? Are you ready for that question? Senator from Wyndham.
Thank you. Just to clarify, I did agree to have the Senate Judiciary Committee look at this bill. It's on our agenda, I believe, for Tuesday. But I don't know that it would be, we'd be able to review it prior to third reading, because third reading would be Tuesday morning, is my understanding. But we are still happy to take a look at it on the planned.
Senator, I might suggest that the President Pro Tem could hold third reading to allow the committee to do some work if that was everyone's choice.
That sounds like a great idea.
Thank you. Question again, shall the bill be amended as recommended by the Committee on Health and Welfare? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and you have amended the bill as recommended by the Committee on Health and Welfare. Question now is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and you have ordered third reading of S210. We now have on the calendar for action H545. It was referred to the Committee on Health and Welfare, which reports it has considered the bill and recommends that the Senate propose to the House that the bill be amended as appears at page 151 of today's calendar, and that with such proposal of amendment, the bill ought to pass. Affecting the expenditures of the state, the bill was referred to the Committee on Appropriations, which recommends that the bill ought to pass in concurrence with proposal of amendment as recommended by the Committee on Health and Welfare. Please listen to the second reading of the bill.
H545, an act relating to issuing immunization recommendations.
I would recognize the senator from Chittenden Southeast for a report.
Thank you, Mr. President. The changes that have occurred at the federal level regarding immunizations have caused some disruption and concern within the medical community, the public health community, and for all of us who question which and what immunizations are currently appropriate. Our Department of Health is very concerned about this and would like to have things stay as they are currently within the state of Vermont, with a commitment to preserve access and coverage of routine and preventative immunizations. And so through this bill, we are doing that. We're bringing a recommendation that came to us from our Department of Health, and we've looked at it, we've acted on it. You'll notice that it is a bill that's come over from the other body, and we took it up because of the concerns that have been expressed both in the state and by our constituents on a regular basis regarding immunizations. So what happens in this bill is to establish and maintain the clear, transparent process for issuing immunization recommendations based on a consideration of science. The bill will maintain the current coverage, insurance coverage and payment for vaccines for folks from 0 to 64. And that will allow for the purchasing program that we currently have in the state to continue as it is within the state. It will also, and that funding program that we have that began a couple of decades ago helps to pay for the vaccines and the immunizations that we have in our state. So I will go through the bill section by section. I want to say that it could be confusing as you read the bill. And two things I'll say. One, we have very limited amendments to the bill as it came over to us from the other body. We just have a couple of small ones. Secondly, I will say that we have the changes that are being made for the state health department with advice to make recommendations about immunization. So the program that we're putting in place will be a temporary program. So there's a date of 2031 where much of the bill reverts to where we currently are in statute. And I'll point out those changes as we go along. So it can be confusing as you read the bill to say, oh, is this changing in 31 or is this staying the same? And I'll try to identify those things so that there's some clarity. But as you go through the bill and just right up, that's it. We'll clarify as we go along. Section 1 of the bill replaces a definition of immunizations and gives that definition that's meaning vaccines recommended by the CDC with a new definition, a new phrase, recommended immunizations, meaning vaccines and other immunizing agents providing protection against a disease pathogen that is recommended by the Commissioner of Health. So essentially what we're doing is we're moving the recommended vaccine immunizations for the state of Vermont from the CDC to the Department of Health. It allows the Department of Health to purchase recommended immunizations from the CDC or another vendor at the lowest cost. So this will continue the fund that we currently have in the state. There will be recommendations about which are the least expensive vaccines to be purchased, and that will be through a process at the department. The first section also makes grammatical organizational changes to the membership of the Immunization Funding Advisory Committee. So the Department of Health, the Commissioner of Health, will have an advisory committee about the funding for immunizations, where to get the cheapest or least costly immunization product. Section 2 is a new section for 6 years, and it places the phrase recommended immunizations into statute, directing the Commissioner of Health to use periodic recommendations on the following. So recommended immunizations for children and adults, the appropriate age for recommended immunizations, the number of doses, the timing of doses, and so on. And then prior to issuing a recommended immunizations, the Commissioner must consult with the Vermont's Immunization Advisory Council, which is currently existent. We'll see later, we make a change here and there with that one, it's very tiny. So the Commissioner will receive advice from the Advisory Council, and that will include folks such as professional groups, will also include the CDC, the American Academy of Pediatrics, the American Academy of Family Physicians, and others. It provides immunity for a healthcare professional who prescribes, dispenses, or administers an immunization pursuant to the schedule recommended by the Commissioner of Health, unless the health professional's action constitutes gross negligence, recklessness, or intentional misconduct. And we did ask judiciary to review this, and I believe that the judiciary may have comment on that section. This section 2 also authorizes the commissioner to issue a standing order to healthcare professionals under certain situations for recommended immunizations. It requires the Department of Health to prominently display information pertaining to recommended immunizations on its website and disclose when the commissioner's recommendations differ from the recommendations of the Vermont Immunization Advisory Council. Section 3 relates to the Advisory Council itself, and this is where your Committee on Health and Welfare did put an amendment in. We took out 2 members who it seemed redundant. We removed the Board of Nursing and the Board of Pharmacy members because there's an APRN, Advanced Practice Registered Nurse, and a practicing pharmacist on the Advisory Council, and that was acceptable to folks. In that section 3, we add the council's duty to provide advice to the commissioner on recommended immunizations. And it also it eliminates the voting process for members of the advisory council who are a part of the education system. Now, the next sections are effective until July 1st, 2031. So this is replacing the word immunizations with recommended immunizations. So as you go through the next several pages, you'll see recommended immunizations under the insurance section in section 4 and under the health benefits plans in section 5. And then section 6 relates to pharmacists, and then section 7 to pharmacy technicians. The section 6 is in existence until July 1st, 2031, and authorizes, in this section, authorizes pharmacists to prescribe, administer recommended immunizations to adults and flu and COVID and subsequent formulations or combination products to patients ages 5 and older, so long as it's consistent with the commissioner's recommendations, and this reverts to underlying statute in 2031. Section 7 is another place where your Senate Health and Welfare made an amendment, and we added language related to pharmacy technicians to clarify what is currently in statute that would allow for a pharmacy technician to administer immunizations when there is a pharmacist in place and it establishes the conditions for that and to which patients 18 and older or 5 and older seeking certain vaccines. It also removes references to CDC recommendations. Then sections 8 through 13 are effective on July 1st, 2031. So these sections allow for a reversion to underlying statute, but also we've made some corrections to underlying statute. So in section 8, amending the immunization funding section restores many of the provisions from current law, but retains language of definition of immunization referencing other immunizing agents to include that in the statute. And then it retains grammatical organizational changes to the Immunization Funding Advisory Committee. Also in 2031, section 9, the Vermont Immunization Advisory Council restores many of the provisions from current law, but retains the changes to the membership of the Advisory Council itself. Then in section 10, effective on July 1st, 2031, The language related to group insurance policies or health benefit plans reverts to immunizations from recommended immunizations. Then also in section 12, the language regarding pharmacists reverts to what's currently in statute. Section 7 is retained for the pharmacy technician. And then section 14 repeals the immunization recommendations language on July 1st, 2031, replacing it with underlying language. So then the sections 1 through 7 and 14 through 15 are effective on passage, and sections 8 through 13 take effect July 1st, 2031. So this, Mr. President, it sounds confusing. It's not. Essentially what we are doing is providing for the Commissioner of Health through the various advisory council on immunizations or the advisory committee on funding to make recommendations to the Commissioner of Health for a period of time that we believe it's necessary while there's confusion at the federal level. In 2031, it could happen before, should the legislature make a decision to change that date, we'll see a reversion to the current status for accepting recommendations only through the CDC process. Well, Mr. President, that is the bill itself. We have took a lot of testimony from folks and tried to wade ourselves through all the date changes and what's here and what's not here. We heard from Legislative Counsel. We heard from the bill reporter, Representative Estes. We heard from Commissioner of the Department of Health. We heard from the American Academy of Pediatrics, the Immunization Program Director at the Department of Health, the Policy Director at the Department of Health, the Legal Counsel at the Department of Health, the President of the Nurse Practitioners Association, Executive Director of the HIV/HCV Resource Center, a member of the Health Choice Vermont, a pharmacist from Vermont, another member of the House, Representative Burt, who wanted to propose an amendment that he had also proposed in the other body. We heard from the Vermont Medical Society, and I think that's it. The vote out of committee was 5-0-0, Mr. President, and we ask that the Senate support this really important bill. Thank you, Mr. President.
Thank you, Senator from Chittenden Southeast. I will now recognize the Senator from Chittenden Southeast for the report of the Committee on Appropriations.
Thank you, Mr. President. Your Senate Appropriations Committee searched high and low for appropriations in the bill. We didn't find anything. So we voted 5-0-2 to recommend the bill to the full Senate.
Thank you. Question now is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Health and Welfare? Senator from Windham.
Thank you, Mr. President. Senate Judiciary did take a look at a very narrow section regarding civil and administrative immunity. That section is on page 172 of today's calendar, subsection C. This section does provide that immunity to a healthcare professional who prescribes, dispenses, or administers an immunization, but they are not immune if they engage in gross negligent conduct or recklessness or intentional misconduct. By a straw poll, the Senate Judiciary Committee unanimously did not have any further recommendations for how the language was drafted.
Thank you, Senator. Question again, shall the Senate propose to the House to amend the bill as recommended by the Committee on Health and Welfare? Senator from Franklin.
Thank you, Mr. President. May I interrogate the presenter of the bill, please?
Presenter will be interrogated.
Mr. President, this is going to be a difficult question, but I just found it curious anyways as to on page 8, on line 6, it has the Secretary of Education and or their designee on this committee, this board or whatever else, and you turn to page 9, Line 8, it says the Secretary of Education or designee shall not vote on this. I was just curious as to what was the reason for the Secretary of Education being on this committee, Mr. President?
Yeah, thank you, Mr. President. That's actually a very good question. So the advisory committee is really basing its decisions on the science behind the appropriate immunization and immunization schedule. And what the folks from education would provide perhaps some advice around school issues, public school issues about kids entering school with or without vaccinations. That was not really a part of the policy that the Commissioner of Health will be issuing necessarily, but it will be a part of the policy that schools will consider. So folks in education will be important to the discussion by the advisory group, but not fundamental to the science of immunizations.
I thank you for sending the bill, and I thank you, Mr. President.
Question again, shall the Senate propose to the House to amend the bill as recommended by the Committee on Health and Welfare? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed, nay. The ayes have it, and you have proposed to the House to amend the bill as proposed by the Committee on Health and Welfare. Question now is, shall the bill be read the third time? Are you ready for that question? If so, all those in favor signify by saying aye. Aye. All those opposed signify by saying nay. The ayes have it, and you have ordered third reading of H 545. That brings us to the end of the orders of the day. Senator from Chittenden Southeast.
Thank you, Mr. President. Pending announcements, I move that the Senate stand adjournment until Tuesday, February 24th at 9:30 a.m.
Senator from Chittenden Southeast has proposed that the Senate adjourn until 9:30 a.m. Tuesday, February 24th, 2026. Are there any announcements? Senator from Washington.
Thank you, Mr. President. Senate Finance will meet at 1 o'clock.
Senator from Washington.
Thank you, Mr. President. Senate Appropriation will also meet at 1 o'clock.
Senator from Rutland.
Thank you, Mr. President, as will the Senate Government Operations Committee.
Are there any further announcements? Senator from Bennington.
The Senate Education Committee will meet at 1:15.
Any further announcements? Seeing none, I would like to close today with a moment of personal privilege. My fellow senators, as of today, I've served nearly 16 years in this chamber. And before that, I served 4 years as a school board member in the Burlington School District. That's fully 20 years of public service. And when the next biennium begins this coming January, I will be turning 65 years old. To my mind, at least, there's only one good thing about turning 65, only one good thing, and that is you don't need any other reason to lay down some of your work and some of your tools. So I will be retiring from the Senate when this year winds down. My name will not appear on any ballot, and of course that means I will not be a candidate for President Pro Tem when the caucus meets this November to choose a leader. I tell you these things today because the good people in my district, Chittenden Central District, deserve time to make a well-considered choice as to who will replace me. The same holds true for this chamber. I have always believed that these sorts of conversations should be longer rather than shorter. There are talented senators and candidates coming up behind me who deserve time to make their case. I think it's important as well that I not endorse anyone for Senate or for Pro Tem, but as we go forward, I'll be happy to offer confidential advice to anyone who asks for it. To be clear, I will continue to do my level human best to lead this chamber until the very last vote of the 2025-2026 biennium. We have many difficult decisions still ahead of us, and I am absolutely ride or die until January. But at that point, I will return to writing and teaching, and the majority of you will return to this lovely chamber which is very much as it should be. On the last night of the session, I promised to bore you all with some longer, more sentimental remarks. For now, though, I will just call the question. The senator from Chittenden Southeast has moved that the Senate stand in adjournment until 9:30 a.m. Tuesday, February 24th, 2026. Are you ready for that question? Senator from Chittenden Southeast.
Mr. President, in light of the very poignant and bittersweet news that we just heard, I think prior to adjourning, although this will likely embarrass Mr. President, and although we will celebrate the pro tem at the end of session as well, this is our first opportunity to thank the pro tem for always being such a forthright and ride or die and committed leader in this esteemed chamber, and to thank him for giving us such an opportunity to have this conversation in advance, which doesn't often occur. So I think with that, I would invite my colleagues, if it's in order, to offer what will be the first of many, hopefully, moments of celebration and affection.
Senator, I very much appreciate the sentiment. It will not be in order. It is no accident that I'm holding the gavel. So I would like to conclude today with that. There will be plenty of time for everyone to say all the things that we would all like to say, but I do appreciate the sentiment.
With that, Mr. President.
Thank you.
I believe I still have the floor.
You do,
And
Senator.
I'm trying to acknowledge some glances and would ask Mr. President if it would be in order that the remarks just made be journalized.
If the senator from Chittenden Southeast, the senior senator, is willing to withdraw her motion, an ensuing motion could be made.
Yes, Mr. President, I will withdraw my motion. Thank you.
Senator has withdrawn her adjournment motion, and I recognize the senator from Chittenden Southeast for her motion.
Mr. President, I would move that the remarks we just heard from the podium be journalized.
Senator from Chittenden Southeast has moved that preceding remarks be journalized. Are you ready for that question? If so, all those in favor signify by saying aye. Aye. Those opposed, nay. The ayes have it, and those remarks will be journalized. My thanks to the senator. With that said, question remains. And Senator, your motion again.
Mr. President, pending any further announcements, I move that the Senate stand at adjournment until Tuesday, February 24th at 9:30 a.m.
Senior Senator from Chittenden Southeast has moved that the Senate stand in adjournment until 9:30 a.m. Tuesday, February 24th, 2026. Are you ready for that question? If so, all those in favor signify by saying aye. Aye. Those opposed, nay.
Hey.
The ayes appear to have it. The ayes do have it, and you have moved to stand in adjournment until 9:30 a.m. Tuesday, February 24th.